This is 180 seconds of what you need to know from the world of litigation and investigations. Let's waste none of your precious time. This is Disputes 180.
Today we're looking at changes to the ICC's Arbitration Rules, which came into effect on the 1st of June. The changes are not revolutionary, but they may indicate the future direction for international arbitration. The central theme is efficiency. Faster, less costly proceedings managed more actively by tribunals. Early establishment of the procedural timetable assumes greater importance. The initial case management conference becomes the cut-off date for new claims, giving that first procedural milestone greater practical significance. Perhaps the most significant change is the removal of the requirement for terms of reference in standard ICC arbitrations. Terms of reference have been a defining feature of ICC arbitrations. Supporters saw them as a useful procedural checkpoint, critics as another source of cost and delay. The ICC has evidently concluded that in many cases the benefit no longer justifies the burden. Their removal means one less procedural stage and a potentially quicker route to a hearing of the substantive dispute. The second major development is the expansion of expedited arbitration. The threshold for the existing expedited procedure rises from $3 million to $4 million, bringing more disputes within a streamlined process, usually involving a sole arbitrator and tied to timetables. More striking is the new highly expedited arbitration procedure. This is an opt-in process available regardless of the value of the dispute, in which a sole arbitrator is expected to issue a final award within 3 months of the first case management conference. Whether parties will embrace that timetable remains to be seen. 3 months from case management to final award is exceptionally ambitious, but the procedure reflects pressure on arbitral institutions to show that arbitration can still offer a faster alternative to litigation. The rules also expressly recognise early determination. Tribunals may dispose of claims or defences that are manifestly without merit or outside their jurisdiction without requiring a full arbitration. Emergency arbitration powers are also strengthened, including the ability, in some circumstances, to grant urgent relief before the other side has been heard. That may be particularly important where assets could be dissipated or evidence destroyed. Taken together, these reforms respond to the criticism that international arbitration has become increasingly proceduralised, often resembling litigation in all but name. The ICC is not merely encouraging efficiency, it's giving tribunals stronger powers to achieve it through active case management and early resolution of disputes. The question now is whether parties and tribunals will use those powers when procedural disagreements arise. If you have questions about these changes, do get in touch. We'd be delighted to help.
And that's your 180 for today. It was brought to you by the wonderful team here at Paul Hastings in London. If you want to join a live version, we host regular events at the Paul Hastings office, including our 2 flagship series, Developments in Disputes and The Future of International Arbitration. To make sure you don't miss out on any of this great content, follow our Paul Hastings LinkedIn page. And if you've enjoyed this edition of Disputes 180, why not look out for the next one? That way, you'll have done a full 360.